So what will you learn? The structure of the webinar will be as follows, with Rebecca and I taking it in turn to address 5 key topics. First, we will recap the basics of the rule against reflective loss, including its origins and development in case law up to the recent Supreme Court decision in Sevilleja and Marex. I will then look at the Supreme Court decision in Marex and some more recent case law, focusing on the 7 conditions which must be met for a claim to be barred by the rule against reflective loss. We will then consider 3 further points, which are somewhat on the fringes of the key judgments, but which are really material to the sorts of scenarios in which advice is often required. And they are, 1, how the rule against reflective loss applies to indirect shareholders. 2, the scope of the rule and its impact for former shareholders. And 3, although these last 2 are very closely linked, the date at which any loss must be assessed. Once we have summarised the legal position, we will then address practical considerations for advising shareholders, including the key considerations for shareholders if a company fails to pursue a claim, the principal grounds for arguing that the rule against reflective loss does not apply, and when can shareholders bring or continue to bring a claim on behalf of the company.
In Nectarus and UCP, the court held that the time for assessing whether loss is reflective or not should be the date the claim is issued. That was a decision about permission to appeal, rather than a decision on the merits. UCP had suffered loss as a result of a breach by Nectarus of duties owing both to UCP itself and its wholly owned subsidiary, Candor. UCP sold its shareholding in Candor and received less as a result of the breach. The court held that UCP's claim was not barred by the rule against reflective loss because the relevant date is the date the loss crystallizes, not the date of the breach. The claim here was not a claim made by UCP in its capacity as shareholder, but instead a freestanding claim in breach of contract for loss UCP suffered when it stopped being a shareholder. UCP, as an ex-shareholder, therefore had a separate and distinct claim from that of Candor, the company. Subsequently, however, in Promeo and Bank of Bermuda, the Privy Council concluded that Nectarus was wrongly decided and that the time for assessing loss should be the date the loss was suffered.